Lawrence v. Texas is going to pick up on earlier cases that have established the right to intimate association. We saw in Griswold that married couples were allowed to make decisions about contraception. In Loving v. Virginia, which you didn't read but which we've talked about, couples have the right to marry no matter what their races are. We saw in Roe v. Wade that the right to privacy that was given to married couples in Griswold extended to unmarried women, unmarried woman and her body and her decisions. And now this right to privacy is going to be expanded even more in Lawrence v. Texas. Now, it's important for you to know that a previous case that's mentioned in this, which was decided in the 80s, I think 85 or 86, I'm trying to remember, Bowers v. Hartwick. Now, what happened in the case of Bowers v. Hartwick is basically the cops went into the wrong house and they found two men having sex. And they said, oh, there's a sodomy statute, Texas sodomy statute, so we're going to arrest you for sodomy. And everybody thought that the sodomy laws were finally going to be overturned. Lots of states had sodomy laws. They were almost never enforced between men and women. They were only ever enforced with same-sex couples, men, pretty much. And so they called it deviant sexual intercourse or sodomy. But it didn't. The court said that the court framed the question in Bowers v. Hartwick as there not being a fundamental right to sodomy. Well, Lawrence v. Texas revisited this because a similar situation happened where the cops burst in on someone in their private home and found two men having sex and arrested them, also in Texas. And it seemed a perfect challenge to Bowers v. Hartwick almost 20 years later. First, they considered the two clauses of the equal protection of the 14th Amendment that I've been telling you about, right? The Due Process Clause and the Equal Protection Clause of the 14th Amendment. When the court says it's granted certiorari, that means the court agreed to hear it. That's just fancy language for the court agreed to hear this case. Okay. So what they concluded, remember we're talking about pretty fundamental rights here. Notice Griswold is being cited. We're talking about pretty fundamental rights here. We're talking about the right adult consensual sexual intimacy in the home. Now, the Constitution is pretty clear that the home is a sacred place, right? The right to privacy in your home. You have the right not to have soldiers stuck in your home. You have the right not to have unreasonable searches and seizures, right? People can't just burst in and go through your stuff. And it had to strike the judges that bursting into someone's home to monitor their sexual behavior, there was something abhorrent constitutionally to that. Notice that one of the questions is whether petitioners' criminal convictions under the Texas homosexual conduct law, which criminalizes sexual intimacy by same-sex couples, but not identical behavior by different-sex couples, violate the 14th Amendment guarantee of equal protection of laws. And I think if the Texas law had said no people can engage in sodomy, they'd be okay. But I believe the Texas law was basically pointed to same-sex sodomy. And so they cite all these cases and basically come up with the idea that there's a fundamental right that's been violated, and people, this fundamental right is one that can't be, the government really has to prove a pretty compelling interest in treating these different categories of people differently, like in treating same-sex couples differently from opposite-sex couples.